In every courtroom across the country, a ritual unfolds. A witness raises their right hand and swears to tell the truth, the whole truth, and nothing but the truth. For law enforcement officers, this oath is not a ceremonial obligation. It is a reflection of their professional identity, their constitutional role, and the trust society places in them. When officers honor that oath, they serve not just their department or their case, but the very foundation of justice. When they violate it, the damage reverberates far beyond a single report, arrest, or verdict. It shakes the pillars of a democratic society. This book began with a simple but profound premise. Truth is the first duty of every officer. Over the course of 12 chapters, we have explored what that duty means legally, ethically, practically, and what happens when it is betrayed. From the individual consequences of perjury and falsified reports, to the systemic failures that allow dishonesty to persist, we have traced the contours of a crisis that is at once institutional and cultural. And yet, this is not a book about despair. It is a call to action for policymakers, prosecutors, law enforcement leaders, civil rights advocates, and the public at large. Complete candor is not a naive ideal. It is an achievable standard. But to reach it, we must be willing to confront uncomfortable truths, dismantle entrenched systems of secrecy, and rebuild institutions on a foundation of transparency and accountability. What we've learned. Throughout this work, several key insights have emerged. Dishonesty is not an anomaly, it's a symptom. Cases of police misconduct rooted in dishonesty, false testimony, doctored reports, hidden evidence are not rare exceptions. They are symptoms of broader structural and cultural failures. Systems that lack effective oversight, that reward results over integrity, and that punish whistleblowers instead of liars are systems built to fail. The law demands more than convictions. From Brady versus Maryland to Giglio versus United States, the Supreme Court has made clear that the pursuit of justice includes the obligation to disclose, to be honest, and to respect the rights of the accused. Yet legal doctrine alone cannot enforce candor. Without mechanisms to track, disclose, and respond to dishonesty, constitutional ideals remain theoretical. Culture is as critical as policy. Departments can adopt model policies and state-of-the-art technology, but if their culture tolerates deception, reform will falter. Culture determines whether officers feel pressure to fabricate, whether supervisors overlook misconduct, and whether the badge is a shield of service or a license to lie. Public trust is earned through truth. Communities, particularly those historically marginalized and over-policed, cannot be asked to trust institutions that lie to them. Trust must be earned not with slogans or press conferences, but with honesty, accountability, and transparency. Where truth flourishes, legitimacy grows. Where it withers, so does civic faith. The cost of inaction. If we fail to act, if we continue to tolerate dishonesty in law enforcement as an occupational hazard, the cost will mount. Wrongful convictions and irreversible harm. Every act of dishonesty risks a wrongful conviction. Every omitted piece of exculpatory evidence, every false statement under oath, can send an innocent person to prison or worse. These are not theoretical harms. They are real. They ruin lives. They destroy families. They cost taxpayers millions in civil litigation and post-conviction relief. Damaged institutions. When officers lie, it is not just their individual credibility that is compromised, it is the integrity of the institution itself. Prosecutors who rely on dishonest officers lose cases. Judges who tolerate untruthfulness diminish their courts. Agencies that protect liars damage the reputation of the thousands of officers who serve with honor. Erosion of democracy. In a democracy, government legitimacy rests on transparency and the rule of law. When those tasked with enforcing the law are themselves untruthful, public faith in government diminishes. Cynicism takes root. People disengage from civic life. They turn to alternatives often less democratic and more dangerous. What must change? Complete candor cannot be achieved through piecemeal reform. It requires a holistic, systems-based approach. Based on the analysis and case studies throughout this book, several reforms are essential. Universal Brady/Giglio compliance. All law enforcement agencies must establish procedures to identify and report officers with credibility concerns. Prosecutors must maintain and regularly update Brady/Giglio lists. Defense attorneys must receive timely, complete disclosures. Courts must enforce these rules with meaningful consequences. Independent oversight. Oversight cannot be internal alone. Civilian review boards, inspector generals, and ombudspersons must have the authority to investigate dishonesty, issue findings, and recommend discipline. Transparency must be non-negotiable. Cultural transformation. Departments must foster cultures where truth is expected and dishonesty is career-ending. This means ethics-based hiring and promotion, scenario-based training on candor and integrity, protections and praise for whistleblowers, leadership that models honesty in word and deed, technological safeguards. Technology should be used to protect the truth, not obscure it. Body-worn cameras, digital evidence management systems, early warning software, and transparent public dashboards can all help prevent and detect dishonesty. But these tools must be used with intention and oversight, a collective responsibility. While the focus of this book is on law enforcement, the duty of candor is not theirs alone. Prosecutors, judges, defense attorneys, lawmakers, journalists, community leaders, and everyday citizens each have a role to play in holding the system accountable. Prosecutors must refuse to build cases around dishonest witnesses, even when the evidence is tempting. Judges must challenge false testimony and exclude tainted evidence. Defense attorneys must vigorously investigate and expose credibility issues. Legislators must pass laws that protect truth-telling and penalize deceit. Journalists must shine light on institutional dishonesty. Communities must demand more transparency, more integrity, more justice. The burden of reform is shared. The duty to tell the truth must be collective. A final word on truth. Truth is more than a legal requirement. It is a moral contract between government and governed. It is the essence of justice and the soul of legitimacy. For law enforcement, truth is not optional. It is the first duty. Without it, there can be no justice, no peace, no trust. And yet, truth does not sustain itself. It must be protected by policy, by practice, and by people who refuse to look the other way. Truth requires courage. It requires systems that reward candor and punish deceit. It requires us all to believe that telling the truth is not only right, but necessary. Complete candor is not a destination. It is a compass. It points us toward a justice system where the badge is not a license to lie, but a promise to protect with integrity, with transparency, and above all, with truth. I am a dedicated author and researcher specializing in the intricate nexus of technology, law, and government. My extensive body of work includes a diverse array of books, scholarly articles, and policy papers that delve into the evolving challenges and opportunities presented by technological advancements within legal and governmental contexts. Through rigorous analysis and insightful exploration, I examine how emerging technologies such as artificial intelligence, cybersecurity, data privacy, and blockchain shape and are shaped by legislative frameworks, regulatory practices, and public policy initiatives. My publications aim to bridge the gap between technical innovation and legal governance, providing comprehensive resources for policymakers, legal professionals, technologists, and academics alike. By addressing critical issues like digital rights, cyber law, technology-driven governance, and the ethical implications of technological integration, my work contributes to the development of informed and adaptive legal systems capable of responding to rapid technological change. I am committed to fostering a deeper understanding of how technology influences governmental operations and legal standards, and vice versa, thereby promoting the creation of robust, equitable, and forward-thinking policies. In addition to my writing, I actively engage with government agencies, legal institutions, and technology firms to offer expertise and collaborate on initiatives that ensure the responsible and effective implementation of technology in public spheres. My dedication to exploring and elucidating the intersections of technology, law, and government underscores my commitment to advancing knowledge, and facilitating informed decision-making in an increasingly digitalized world.